Deadly disaster number 4. They've stolen my ideas. The Video News Factory, who are videoing this, have found some fantastic material here. And you hear this in the news a lot, don't you? There's a big case from Dyson alleging Samsung have stolen their IP, stolen their ideas. Look quite similar, don't they? It does happen all the time, and we probably, I mean, I've known of people who've gone to large high street retailer with some ideas, designs and drawings, and they say, oh, that's very good, thanks for coming to see us, and then the designs appear in the shop 6 months later. You know, some apocryphal stories going on about certain stores. And it does happen a lot. And in the internet age, of course, we're now talking about hacking and the need for cyber security. You're never going to fight a big IP case in the High Court because it's just out of most people's league. But the Samsungs of this world will sue and sue and sue, and they do. And there's been lots of court cases with Apple and Samsung and so on.
So if you have what you think is a winning idea,
yep,
and you go to a big company, what can you do beforehand to kind of help?
There's more of that. NDAs.
They're legally binding?
Yes. English people call them confidentiality agreements, but NDAs, non-disclosure agreements, quite neat. So we've all got a bit lazy and become a bit American. They're NDAs. You need an NDA, non-disclosure agreement. They're binding contracts. I mean, enforcing them is a different story, but people will take you seriously. They're not very difficult to draw up. We've got loads of templates for them. So it's a non-disclosure agreement. What you're saying is, we are entering a discussion about my idea. I'm going to give you some confidential information, and you're going to keep it secret. Not only are you going to keep it secret, you're not going to use it for your own benefit. And you make them sign a contract. There's some wrinkles associated with it, because you've got to make sure you've identified the parties, not just a bloke you've met in the pub. You need to know who he represents, and whether he's got authority to represent the company. And you need to identify what it is that you're talking about, what the project is, what it is that you're disclosing. So these are a little bit of thought. But they do work, and I think people will take you seriously. And I know people have churned out dozens of NDAs. Every time they go and talk to somebody, they have an NDA. And particularly if you're looking for investment and you've got a whizzy idea, you don't want everybody to know about it. Now, of course, people will be dishonest, and it may be that they will copy your idea, take your IP, but at least you've got something. And one of the solutions might be licensing. We might be able to talk about that later. You could license your idea rather than stopping them, but that's some way down the road. But start with an NDA. It's not that difficult. It shows you mean business.
I think one of the things is chicken and egg situation. You propose an NDA before you disclose an item or idea that you have.
Yes.
To be implemented. Now this person comes along and says, yes, I'm happy to sign it off, because he doesn't know what what the project is going about. But then it is discovered that he already has that idea. There was nothing new about it. So that NDA becomes void. How do you actually...
Pre-existing, if he already knows about it,
yes,
doesn't work.
So,
doesn't work.
I mean, how do you actually iron that
well,
out?
people, you can't.
You
can't. I mean, if you came to a fight, he'd have to demonstrate that he hadn't taken the idea. And this is where, you laughed, rightly so. Enforcing is a different ballgame, because it comes down to the facts.
Because people can be fickle.
People can be fickle. Yes,
they
could.
And then they say, oh, we already had it.
Yeah.
And they can manufacture
false
evidence.
Prove it.
They can manufacture false evidence, whatever they can.
Well, you'll be able to prove that you had the idea beforehand. Let's not talk about litigation, but most people will take these things seriously, because they don't like to sign on something, but make them. They'll say, oh, I'll do it later. Don't you trust me? That's the worst thing of all. Don't you trust me?
Is it possible, before you progress, that I put my idea on a piece of paper
Hmm.
and
Date
attest
it.
it to myself
Date it.
by
Yes.
recorded delivery.
Yep.
And leave it sealed.
Yep.
Until the end day when I really have to prove it, so that when the courts unseal it,
Yes.
they will have the evidence.
Send it to your solicitor. Or
And
put
it's
it in the
also-
safe.
Yeah.
Yeah.
That's what I did
Yeah.
in case of one
Good
law I
idea.
decided.
Yeah, that's fine. You can do that. You can do similar things with your staff as well, because they have obligations of fidelity to their employer anyway, so they're not supposed to. But you can have specific clauses that deal with intellectual property. If an employee creates intellectual property in the course of their employment, the employer will own it. But beware contractors. If a contractor creates it, make sure they assign it to you, sign it over. Because IP starts with the creator. And if you've got a contractor who's not employed, they will own the IP. Don't get caught out. Particularly with websites as well. That's always a good one. I want my website. You can't. We own the content. But it's our website. You know, if they created it, they own it. And then physical security is another whole topic, you know, not having data sticks lying around and what people do with their laptops and bringing their own devices in and using their own phones at work and all this kind of stuff. In some companies, they take the phones away from you when you go in. You know, you're searched. You can't have a phone in because they don't want you to take a photograph. So just think about physical security if you've got some technical ideas. It's a massive topic.